there were no tapes of any of the shows. The plaintiff took a shotgun approach and named a number of stations in a particular market, and it was just a free-for-all because all of the defendant stations were denying that the particular statement had ever been broadcast on their air. Ultimately, that's the burden of the plaintiff. They're going to have to be able to prove that, in fact, there was a publication. Most times, not an issue. Second, identification, that the statement was reasonably understood by people who knew the plaintiff as referring to him or her. Again, oftentimes not much of a dispute, particularly if the broadcast content specifically names that individual or describes that person so specifically that the reasonable listener would be able to clearly understand that the plaintiff was being identified. But obviously, in terms of a defamation claim, there has to be a false statement of fact that is broadcast. The issue there really is whether that statement is going to be identified and recognized as a statement of fact versus a statement of opinion, which is constitutionally protected. Damages, the plaintiff's going to have to show that he or she suffered some harm to reputation. May not be required for them to actually establish out-of-pocket losses or out-of-pocket expenses, but to be able to show that their reputation was somehow harmed by the broadcast. And then probably the element of the defamation claim where honestly most of the litigation seems to turn these days is the required degree of fault. The plaintiff is going to have to show that the broadcast was made with a required degree of fault. That's either the constitutional actual malice standard or the negligence standard. And if the plaintiff, as this slide shows, is a public official or public figure, then he or she must prove that the publisher made the statement either knowing it was false or entertaining serious doubts as to its truth. On the other hand, if a plaintiff is a private individual, then probably will only be required to prove that the publisher or broadcaster acted negligently. That's a huge, in terms of the legal significance of the claim and the burden on the plaintiff, that is very significant. And that's why in many of these cases, there is so much attention paid to what's the status of the plaintiff? Is the plaintiff a public figure or a public official rather than a private individual? Because that status will determine the degree of fault that the plaintiff must prove in a liable case. Oftentimes, again, may not be all that difficult, particularly when we're talking about an elected public official. The issues really surround, well, what about people who might be employed or staff members of the elected public official? What happens if they're not an elected public official, but they're so well known in the community that they can be determined to be a public figure for purposes of this particular broadcast or content? That really is an important aspect of the analysis. It, from a risk management standpoint, when you're vetting a potential broadcast, pre-broadcast, that's clearly something that's going to be important in the discussion about who are the subjects of the broadcast content. If someone is upset or challenges the broadcast, what's their status? Would they be determined to be a public plaintiff or a private plaintiff? That may result in the way some issues are or some subjects are treated in connection with the broadcast content.
Here's a question in relation to that. If someone sets up a regular Twitter feed on a newsworthy topic, do they become a public figure?
I would say I'd say there's a good chance. Again, depending upon how that's done, I guess the issue would be, or the way I would see that, George, is the person who sets up this Twitter feed, may be, voluntarily injecting themselves into the discussion, into the, what the legal cases talk about, the vortex of the public debate on the issue. If they're simply providing a feed that provides some of this source, maybe it's a closer question. But if they are then joining the conversation about it, I think there may be a claim that they've injected themselves into the debate, maybe voluntarily becoming a public figure for the purposes of that issue, if I'm following your question correctly.
I think that was,
Yep.
John, if that doesn't answer your question, let us know, but I think that may have addressed his question.
Okay. Plenty of, there's just so much we could talk about in the issue of content claims and defamation, but one thing that I want to, before we move off of the topic, not to completely ignore, is the issue of post-broadcast retractions, corrections, apologies. These are critical. Not so much that they're defenses to a claim, but quite frankly, as a practical matter, they can provide, if handled properly, substantial mitigation of the circumstances, and may in fact serve to completely derail and prevent a libel claim or defamation claim from ever being brought. So it's clearly when a call is made to the newsroom, someone may be upset or asking questions about broadcast content. It's important that it be handled very sensitively, and that newsroom managers and potentially lawyers for the newsroom are brought into play pretty early on in dealing with the strategies which may help to mitigate damages and prevent a lawsuit from ever being brought. Editing practices that may lead to libel privacy claims. Again, we could spend a lot of time on this type of an issue, but clearly there's some categories of things that we have seen over the years that can result in the type of claims that we've been talking about. Particularly in a broadcast medium where time is limited. So there may be, that may lead to editing practices that oversimplify a story, taking a complex business or criminal story and oversimplifying it. Compression, again, on many of the details to a more general or summary fashion. Unbalanced unfairness that we'll talk about at the end. Incorrect references to areas of technical expertise. Again, so the more technical or complicated the story may be, may provide some challenges when we're talking about a broadcast medium. Here's a slide that, again, not to suggest that these words can't be used, but we've certainly seen over the years that these are flashpoints. Selected words and expressions typify the numerous words and expressions that may lead to a libel or privacy lawsuit if not carefully handled in a news story. Any words or expressions imputing the words that you see on this screen. Again, not to suggest that you can't use these words, but if I'm vetting a story pre-broadcast and I see a healthy or aggressive use of some of these words, I'm looking pretty carefully at the context of the story and making sure that these type of words, because they are what I'd call the red flag words, there's going to be a reaction, certainly. Okay, issues, again, kind of content issues and challenges with the online digital content. And everybody is focused on their websites and their blogging posts, and so the issues often arise is, all right, if we're getting third-party posts to our blogs and to our websites that that may be problematic, may be defamatory, may be offensive? Who's going to be liable for those postings on your website? Well, again, if it's third-party postings by others not connected with the station or the website, that's user-generated content, and Section 230 of the Communications Decency Act still holds and still provides an immunity to the website or the internet service provider against any claims relating to that third-party content. Again, legal claims. But if you're the blogger, if you're posting a blog on your newsroom website, both the newsroom and yourself, again, as the publisher and provider of that content, may be responsible. So if you're posting it directly, you may be responsible for claims arising from the content. If it's posted by a third party not connected to the website or to the station will not face liability or claims relating to that content. Okay. The potential claims, again, we've seen them before. Traditional type content claims, defamation, invasion of privacy. I honestly think that and again, it goes back to something that we've said before, most of the claims that we seem to find ourselves tangled up with these days relating to digital or online content are really more on the intellectual property side. Again, the copyright infringements, the trademark infringements, essentially grabbing other people's content and cutting and pasting in today's world into your website without permission and certainly without attribution. That's where we're seeing a lot of the issues and a lot of the discussions these days on these type of claims. Here's some information, kind of statistical, that the Media Law Resource Center provides. Media Law Resource Center, as many of you may know, is a nonprofit organization, media organization based in New York. In the last several years, some of these statistics are a bit dated, but they've been trying to pay attention to blogger cases and internet posting cases. There was a sense that there would be an explosion of litigation created by bloggers, and honestly, we've not seen that. Certainly there are claims out there being raised, and they can be very serious claims. I think part of the practical problem may be that oftentimes potential plaintiffs view a blogger as might not be just worth their time. They may be judgment proof. They may not be backed by a credible media organization, and it may not be worth pursuing. Hard to say, but here's some statistics that thought were pretty interesting. I think one area is really the last bullet point on this slide. Anonymous bloggers were parties in 42 cases and unmasked in 9 cases. That often is the motivation behind some of the cases being filed here. You've got an anonymous blogger who may be creating some issues for a subject who, their main motivation is, I want to find out who this person is. And so legal actions may be instituted with attempts to get at or get behind the identity of that anonymous blogger. That can create and catch in the middle some media organizations whose blogs or websites, there are comments posted by anonymous bloggers, which somebody becomes interested in, and then the media organization may find themselves in the middle of a subpoena battle and request to turn over or identify the identity of those bloggers. It's been something that we've seen a fair amount of.